Hello, everybody. As you are all joining in, I hope you're getting settled well. Here's wishing you a happy Wednesday, and thank you all for joining us for the Center for Art Law's Art Law Lunch Talk on Museums and Deaccessioning. My name is Manali Manukian. I'm the Executive Director for the Center for Art Law, and again, thank you so much for joining us. You will see on your screen a poll. While I take the time to let you know a little bit about the center, we'd love to get to know a little bit more about you. For those of you who are unfamiliar with the Center for Art Law, we are a research and education organization dedicated to offering resources and programming for the advancement of a vibrant arts and law community worldwide. Through our website, our newsletter, and our events, we disseminate information and try to keep our audience updated on all art law related news, programs, cases, publications, and even more. The center facilitates conversations by hosting and participating in programs such as today. And we have a great internship program as well that allows students to get firsthand education and experience in art and cultural heritage law. A special welcome to all of our premium members that are present today. The Center for Art Law couldn't be the success that it is without the support of other amazing art law fans in the community. If you're interested in discounted or free access to our events or access to past recordings of events and our case law corner, please consider signing up for our premium membership. We also invite you to subscribe to our newsletter to receive updates and invitations, and to visit our website at www.itsartlaw.org. We have an amazing list of programs that are coming up in the near future as we kind of wrap up our fiscal year. And on that note, I wouldn't be a good executive director if I didn't ask you if you have a few dollars to spare to donate so we can continue to put on amazing programs like the one that we are hosting today. We have 2 events coming up in the very near future with the National Arts Club here in New York City. So if you are having a hankering for an in-person event, we have the option for you. They're based on our visual artist legal clinics. So the first will be on artists' trusts and estates, and another based on our new clinic that we will be launching soon in July on artist-dealer relationships. Our Some Like a Digital series is back. We're talking about the metaverse and domain names in the coming months. And we have some amazing other programs based on our new artist-dealer relationships clinic coming up in the near future. Before the program begins, I do have a couple housekeeping notes in case you haven't noticed already. The program is currently being recorded for archival purposes. Feel free to turn off your camera if you're feeling uncomfortable being on the screen for that. And just make sure to keep yourself muted to prevent any background noises from interfering with the conversation. We will also be taking questions after the presentations. Feel free to utilize the chat function. Put any question that you may have during the conversation there. We'll be monitoring the chat and we'll be gathering all those up to put together at the very end. And a link to the handouts with bios and reading materials will be put into the chat just soon. They'll also be emailed to you again after the program, along with a brief survey, which we'd really appreciate that you fill out, which we'll use the results to bring more events and speakers of interest to you. Now that all of that is out of the way, let me introduce Irina Tarsis, the founder and managing director of the Center for Art Law, who will present the speakers and give a substantive overview over here. Irina, take it away.
Hi, thank you, Manali. Thank you very much to our team, Atreya, who's on the call, and many, many thanks to our speakers for joining us today to talk about museums and deaccessioning. The poll is still up. We're hoping to get a few more responses in before we close it. In the meantime, I'm going to help us adjust our attention, I suppose, or look at the subject matter that we're presenting, the center is presenting today. So museums have been around for a very, very long time, and not always for the better, and not always equally embraced and accessible to everybody. But I am a big fan of museums, and I try to go to as many as possible whenever there's no pandemic or whenever there is a window to explore a new place. And not a day, it seems, that we can go without thinking about museums or hearing about museums. This is a little lineup that I put together for you. As you can see, my attention is very much focused on the Russian-Ukrainian war. So you have at least 3 headlines on this subject. One most recently from this past weekend, where a museum was destroyed by a missile strike. So from physical damage to museums to digital explorations of museums, there are lots and lots of subjects to discuss, and there are many, many experts and participants and interested parties who are looking at what museums are doing, how they're doing what they're doing, and whether they can be supported, how, or stopped in their tracks, and why. So museums have their own internal mechanisms of dealing with issues, their external mechanisms with dealing with issues, and our speakers are going to talk about these, both international and domestic and state-based regulations and suggestions, soft laws and court-made laws, just to bring our focus from the outside of the world, or the United States, inside to particular states. You may remember that back in 2014, when we were all living in different worlds and lives, there was a Delaware Art Museum deaccessioning, just one of many headlines, which did not go unnoticed. And unfortunately, for the museum, at least, the results of that particular deaccessioning exercise were not as good as curators had hoped. So from the struggle to choose what to deaccession, how to do it, and whether it met the obligations and expectations of the curators, this was a very interesting story. Another story more recently from 2017, 2018, where the Berkshire Museum announced their plans to deaccession materials. There was a contract with Sotheby's entered into by the museum staffers, or authorized individuals. There was a very relatively protracted lawsuit trying to prevent museum from selling artworks in their holdings. And there was an AAMD statement regarding sanctions the Berkshire Museum felt levied upon it after the deaccessioning actually took place. And some works did sell. The museum raised over $53 million for their purposes. In 2020, which also sometimes feels like a lifetime away, something happened in the world which allowed museums perhaps to relax their policies, whatever they were. And we know that a number of museums, from Brooklyn Museum to Baltimore Museum, contemplated and either went through with the plans to deaccession or changed their plans for some reason. So what does it all mean? Is deaccessioning a taboo subject? Well, not, because we are talking about it and lots of museums are doing it. Collection management plan from the Metropolitan Museum of Art from 2021 discusses deaccessioning. And by the way, Metropolitan is also selling some pieces. It's documented in headlines and articles and their internal documents and auction house catalogs. Met says they've always practiced it. So if they can do it, why not others? Or who's next, I suppose. So to get us thinking about the mechanics and what is deaccessioning, we have 2 wonderful experts with us. We have Jill Deupi, who is a Ph.D. in art history and a lawyer. So this is kind of a double bonus, or yes, I would say double bonus, who is with Lowe Art Museum. And Jill is going to be talking about how, if, and when museums do deaccessioning. I will let Jill make a couple of remarks, and then I will introduce our second speaker, and then we'll have a conversation on what it means, how it's done, and how it ought not to be done, deaccessioning. Jill, welcome.
Thank you, Irina, and thank you, Manali, for your assistance and technical support, as well as the invitation to be here today. Hello, everyone out there in Zoomlandia. I just want to make clear that I am here as a museum director. So though I have a JD, I only play a lawyer on TV. So I really am here representing not only my own views, not those of my institution or those professional organizations with which I am associated, but again, as a museum professional. I think what's really fundamentally important for everybody to understand if deaccessioning is something that's new to you is that it's actually okay. There's nothing wrong with deaccessioning as a concept or a premise. It is part of normal operations, and it is actually key in many cases to maintaining a healthy collection. So although deaccessioning has something of a bad reputation in the last couple of years, decade actually now, plus since 2008, I think, with the firestorm that was Brandeis and the Lowe Art Museum, it really has, it carries a taint that is not necessarily de facto. I think it's also important, I think Katie's going to say a little bit about this as well, to understand that what's causing the headlines is not deaccessioning by and large. It's actually the use of proceeds. So I just would like you to keep those foundational baseline concepts in mind, that deaccessioning is not problematic in and of itself, and that deaccessioning is really not the trigger for so many of the controversies. It's really the controversies rather are being catalyzed by the proposed use of proceeds.
Thank you very much. So deaccessioning is done. It's okay. The question is how it's done, who does it, and how the proceeds are used. So this is the parameter of our conversation today. And our second guest is Katie Wilson-Milne. She is a partner at Schindler, Cohen and Hoffman law firm in New York. And Katie is going to not only play a lawyer on TV, but she will be our legal expert on what is permissible and how in the deaccessioning realm. Katie, welcome.
Hi, everybody. I'm happy to be here and be reunited with Jill, who's we've done an event before where we chatted about these issues, which was a lot of fun. So I totally agree with everything, Irina and Jill just emphasized, which is that deaccessioning, incredibly common. It's as old a practice as museums are, not controversial. It's a healthy part of collections management. And really, it's not even so much how deaccessioning is done, with the exception of maybe we can talk about the Baltimore Museum a little bit, but I don't think of a lot of examples where how deaccessioning is done is that controversial, but how the funds are used has become controversial because that's changed as sort of the social milieu, and pressures on museums have changed over time. So in terms of the framework, legal and sort of pseudo-legal framework we think about deaccessioning, they come in a few buckets. One is state laws, namely not-for-profit laws. New York has a very robust not-for-profit organization law, which governs conflicts of interest and obligations of stakeholders and fiduciaries. And also, New York is the only state in the country, so this really only applies to New York as far as I know, that itself has regulations that speak to when museums can deaccession works and how those proceeds can be used. And that is in the Regents regulations. And in New York, Regents, the New York Board of Regents, which governs all educational institutions or degree granting institutions, also governs museums, collecting institutions. And they have a set of regulations that cover deaccessioning and the use of proceeds from deaccessioning. And very briefly, those rules allow for deaccessioning in situations just like the AAM and AAMD, which are the ethical bodies that we'll talk about that govern deaccessioning. And they allow for the use of proceeds to acquire new works, and also for the direct care of collections, which has become a key term. So they are very much in line with AAM, not AAMD. We're going to be talking today mostly about art museums, which is why AAMD is relevant. AAM governs all museums, and as far as I know, their guidelines have not been particularly controversial, nor have museums more broadly than art museums been changing their practices with respect to deaccessioning.
Thank you. So these are the subjects that we are discussing, and we are actually going to start with a very basic question, probably to Jill. What is deaccessioning? Can you tell us, not the definition, but from the museum's point of view, what is that? And then Katie, from your point of view, a legal point of view, what is deaccessioning?
So I think that it's probably helpful to understand that deaccessioning is by definition preceded by accessioning. So what accessioning means in the museum is that you've accepted a gift of work, or you've acquired a gift of work. Sorry, you've acquired a work of art by gift or otherwise by or purchase, etc. There are multiple ways, of course, to acquire a work. You can do several things at that point. You can leave it in a kind of holding collection for a period of time if it's something that's really not museum quality that you want to use for hands-on teaching and learning. You might assign what's called, at least in our museum, a T number. But if you want to include it in your permanent collection, and really that would be the norm, it would be very unusual to accept something as a gift or acquire something without the intention of adding it to the permanent collection. So let's assume that that's what's going to happen. At that point, the collections management or registration team will assign it a permanent collection number. It's called the accession number. And you probably know this, but if not, it's kind of a fun factoid for you all. The next time you're in a museum, if you look at the object label, something that we call the tombstone label, which is just all of the facts of the work of art that you're looking at, typically you will see at the bottom a long string of numbers that will say something like 2022.5.8. And that simply means that this gift or this object came into the permanent collection in the year 2022. It was the 5th work that came in, and this was probably the 8th object in that 5th gift. So that's the accession number, and that's what accessioning is all about. It really is a collection management tool, a database tool in many instances. So fast forward to several years later, a decade later, whatever the case may be, you've decided based on your collection management policy, where you will have as an accredited or professional museum outlined, documented the criteria for deaccessioning a work of art. And typically those would be such things as the work is duplicative, it no longer meets the mission or advances the mission, you do not have the resources to adequately care for it. It has been proven to be of modern manufacture, which is a nice way of saying fake, so on and so forth. Those are just kind of some of the standards. So based on the collections management policy, you go ahead and follow the internal protocols for deaccessioning. And usually there are many different layers in terms of not just approvals, but also research, because you're going to want to look at the donor file. I know Katie's going to talk about contracts later, so that's also something to be aware of, as well as donor relations. You jump through all of those hoops, past all of those hurdles, and then you can deaccession your work of art. And guess what? Nothing happens except that the record is changed. That number is removed. There is now documentation to show that the work has been formally deaccessioned from your museum collection, but it's still going to be sitting on your shelf. Again, nothing in terms of the physical object happens at that stage. So it really is, it is about collections management and the associated record keeping and the database as well.
And Katie, from your point of view, what does deaccessioning mean?
I apologize to everyone if you hear a screaming baby in the background. That is mine, but he is fine. So Jill mentioned the two other sort of frameworks we look at when we're looking at deaccessioning. Deaccessioning is not a legal term. I mean, it means literally a piece of an object from a collection is exiting that collection. Just like it enters the collection, it exits the collection. So I think Jill defined that really well. But in addition to these state law issues, whether that's the New York Regents rules or not-for-profit rules that would govern museums in different places, we do look at any contracts that have been entered into with respect to a work of art. That usually means donor restrictions. So the institution will want to pull the file and see if there was part of a restricted gift. Those types of gifts are rare now because museums don't want to accept them, which is smart, but they were not always so rare. So especially if an object was gifted to a museum a long time ago, it could have been part of a restricted gift that either forbids or limits or qualifies any kind of deaccessioning that can occur. And the other is this body of what we call governance documents. Jill talked about a really essential one, which is the collections management policy. Museums are essentially required, they actually are required by Regents, which governs museums chartered in New York after the 1880s. And by best practices, to have collections management policies. So it's certainly not the Met. The Met wonderfully puts its online, as many of them are supposed to make public, but basically every museum has at least some form of a collection management policy or is required to. And those policies, once adopted by the board of a museum, the board is the governing body that runs the museum and delegates its duties to staff members, just like happens in any nonprofit. That board will adopt these policies in addition to the museum's bylaws, conflict of interest policies, and other types of policies that tell the museum how it runs. And once those policies are adopted, including the collections management policy, they do become legal documents that need to be followed. And so one really important thing for museums and museum professionals to keep in mind is that it's extremely important to have policies that are followed. In fact, we often say in different contexts when we're advising clients that it's worse to have a policy that you don't follow and don't do anything that it says, because you're creating legal liability for yourself. So these policies are very important, and they can all govern how the museum goes about things and processes like deaccessioning, including as specifically as a collections management policy that will have very, very detailed instructions on how and where that can occur.
And who makes the decision on what is to be deaccessioned? When is this decision made? Jill, starting with you probably.
Sure. It really should start at the curatorial level. I think where some of the issues that we've seen lately have come from is inverting the process, right? Really, you should have your curator or curator saying, or identifying as part of ongoing collection surveys, this seems to fit the criteria for deaccessioning. It should be considered as a possible deaccession. And then you go through all the steps that we talked about, and then you start thinking about where you want to use those funds that are realized through the sale of the deaccessioned work, the disposal of that work, rather than the inverse, rather than finding that you have a structural deficit in your budget and then thinking, ooh, what can we possibly sell? And I don't say that lightly, because I understand that I live the pressures of running a museum in the US, and I understand how that formula can very easily and for all the right intentions be inverted, but it really should start at the curatorial level in tandem with the criteria laid out in one's collection management policy.
So if we have best practices, do we also have worst practices in deaccessioning?
I think that, again, it's that inversion that would be the worst practice. Deciding that you need to raise X millions of dollars, or you're going to potentially have to not only lay off staff, but close your institution. And it's often one of the risks that's often referred to is using the collection as a piggy bank. And that would certainly be the worst practice, I think, in this context. And not only does it violate public trust, lowercase t, but it also, perhaps in New York in particular, runs the risk of violating some state laws. But it also, I feel, doesn't really solve the root problems. Oftentimes, if you have these kind of really significant financial issues, the Band-Aid is not going to necessarily get you back on level footing. And that's one of the risks that we find. There's also the very complicated, and I don't know that we want to go down this road. If we do, I'll look to Katie to do so, of FASB, of triggering FASB issues too, which is something that has been on our radar in the museum field for a couple of years.
Katie, can you respond to the same question? What would be bad practices from who has duties and which duties might be violated by bad practices in deaccessioning?
Well, I'll answer the first part of that. I'm not sure about the duties, but I think that really is the staff at the museum, following the collections management policy and the ethical guidelines, either the Association of Art Museum Directors, AAMD, or the American Association of Museums, AAM, that the museum subscribes to. So there's sort of soft duties, and of course there are the fiduciary duties that the board and the executives of the museum have as well, to act in the best interest of the museum. But I agree with Jill that the real issue here is that there's been a debate, and I think a real push among some museums to think about how to raise money in really difficult circumstances. And the pandemic kind of opened a box to talk about that, but these pressures were all here before that. And I don't think the pandemic, at least for the big examples we're talking about, was the actual financial problem. It just sort of opened up this debate. But the real issue is, when a museum needs money, can they think about deaccessioning? And that's sort of the opposite, as Jill said, of what has been the accepted practice. But just to give a little background for why those pressures are real, and I'm agnostic and somewhat suspicious of a lot of these deaccessioning pushes recently, but I do think it's worth noting that a lot of American museums that are not on the coast, art museums that are not on the coast, were once in very, very rich donor circumstances in the Midwest, upstate, in the Berkshires. And those philanthropic pools dried up in a way that they did not in California and in New York and in other big coastal cities. And those communities are largely now working class. They don't have very wealthy boards, at least very wealthy giving boards. And so they have felt the crunch of caring for enormous collections, which are very expensive to maintain. Many of the pieces, if not most of the pieces, are not usually on display. So it's really just the expense of caring for works in storage. And they have these pressing operational needs and expenses that they also need to meet and are struggling to meet. And so I think you have this confluence of circumstances where it's very hard not to look to art, as the art market is skyrocketing in value, and they know that they could sell one or two pieces of works that they're not, aren't even on display, or may not even be on display, and solve some of their budget problems for a while. And I think it's harder for those institutions to hear from sort of a philosophical or ethical point of view that they shouldn't do that because it's just not the right thing to do. And I think that's sort of where at least what I see as sort of the original debate and pressure around this issue come from. I think we're now seeing coastal museums like Brooklyn and the Met and even MoMA and other even smaller but very high profile museums are also taking advantage of deaccessioning to and using funds in more creative ways than just buying new works of art, which was the original restriction. So I think it's worth just thinking about those pressures and how we provide an answer to them if we're not going to allow museums to sell works of art to pay for their operational expenses, which is the big prohibition.
Right, but before museums, and we'll talk about the controversies that we have seen following during the pandemic, but museums can deaccession without selling, right? They can return property back to the donor or their heirs. They can also arrange for the piece to be placed in another institution, effectively taking it off the books in their storage and facility and placing it in another nonprofit or publicly accessible place. So deaccessioning does not necessarily always mean selling. And sometimes deaccessioning is probably just I'm not trying to be in headlines, but something can be thrown away because it's destroyed, right? That's also a form of deaccessioning.
Yeah, or fake. That's a really good point, Irina. I think we, or at least I, assume this talk was about selling because the the headlines and the talk about deaccessioning is about the need for money and cash. So it's usually not controversial or really the subject of any discussion, the many ways museums deaccession without selling. But that's absolutely right. And those are all permissible.
Yeah, I just want to second that. It's an excellent point, Irina, and an important one. You can absolutely dispose of an object by destruction. Now, there are guidelines, or there should be in your collections management policy. You really do have to document that, or you should, in terms of the destruction. You don't just throw it in the garbage typically. You literally destroy it, so that if there is an issue, if it's fake, for example, it wouldn't ever possibly appear back on the market, etc. But also, and this dovetails interestingly with some other really, really important headlines of late. You need to deaccession before you can restitute or repatriate ancient works of art, things that are culturally sensitive, anthropological, ethnographic, etc. So I do think that yours is a really excellent point to raise, that this verb deaccession can precede many different ways of disposal that follow.
Right. And in some institutions, just as a follow-up, and in some institutions, the lack of deaccessioning policy or a particular mission can be used as an argument against restitution and deaccessioning. If an institution does not deaccession, then it cannot return something that was improperly accessioned in the first place. But it's something for us to remember that deaccessioning does not always equal sale and proceeds to be used in some other way. But when we talk about deaccessioning for this purpose of raising funds for other uses or any uses, Jill, can you talk about the, again, repeat, what are the permissible uses theoretically? And what uses tend to bring ire of AAMD?
Sure, I'm going to just level set here a little bit. Forgive me, those of you who know this already, but I want you to understand that there are really two professional organizations that the field looks to in this context. The larger one is AAM, the Alliance of American Museums, and that represents all collecting organizations. So whether you're collecting trees or bugs, or I guess you're not collecting children, but if you're a children's museum or an art museum, you can be a part of AAM, and they are also the accrediting body for museums in America. And you really do want to have their stamp of approval. AAM accreditation is a very big deal, and justifiably so. The last number I heard in terms of membership was north of 5,000, to give you a sense of scale in terms of membership. At the opposite end is AAMD, the Association of Art Museum Directors. In full disclosure, I'm one of their trustees, but I am not representing their views here today. They have only about 225 museums, and as the name suggests, limited to art, in this case, art museums in North America. So Canada and Mexico are also included. AAM has a more relaxed standard. So the use of proceeds from the sale of deaccession works can be used to either replenish the collection, i.e. buy more art or bugs, whatever you're collecting, or the direct care of collections. And there's a white paper. Manelli, I don't know if you can work some magic and send drop a link in the chat to AAM's white paper on direct care of collections, because you may find it of interest, where they try to explicate what this means. And it's not really defined in concrete terms so much as there are guidelines. There's a matrix there that's pretty helpful in terms of nexus between care and mission and those sorts of things. So that's really helpful. AAMD, however, is more restrictive. There was a 2-year relaxation period that has now expired, but leaving that period aside, and we can talk about that if there's time and interest, but leaving that resolution that again is now expired to the side, AAM only permits the use of those proceeds for the replenishment of collections. So in other words, buying more art. There is no direct care exception at this point. There was, again, between April 2020 and April 2022, we have now gone back to where we were before that resolution, which was temporary by design, was in place.
We have a question from one of our attendees. If a museum does not have a collection management policy, how can they ethically go about deaccessioning works from their collections?
I would be surprised if a museum didn't. You need it to be accredited. There's a whole list of core documents that you need to be accredited by AAM. Now, not every museum is accredited. And I'm only, I should say, speaking for art museums. That's what I know. I can't speak for the other typologies, but I do know that smaller museums sometimes are not accredited, but even they, I can't even think of a single exception, try to hew very closely to those standards of best practice. So I suppose you still absolutely could deaccession ethically, following basic guidelines. You know, you're not deaccessioning willy-nilly, you're not deaccessioning something that is core to your collection, you're not deaccessioning something because it's high value and you want to basically cash out. Those would be, I think, pretty blatant breaches of ethics, whether or not it's in your, well, even if you don't have a collections management policy. But again, I struggle to think of a museum that would be in this situation and not have a CMP, a collections management policy.
I just add to that, too, if I may, that we have seen, because these standards are, for the most part, other than in New York, where the Regents guidelines very much mirror AAM, meaning the broader ethical guidelines that allow proceeds to be used for direct care. And not all museums in New York, like the Met, for example, formed before 1880, not technically falling under the Regents rules. But so in most places in the country, we're just talking about these ethical guidelines, and museums are free from a legal matter to not follow them, right? I mean, they're voluntary membership organizations. And so the bite, if you don't follow them, is that you get sanctioned, meaning like other museums can't lend to you, or you get kicked out as a member. And that does have repercussions. That's, cultural, social repercussions, practical repercussions as well. But museums do decide to do that. The Delaware Museum decided to do that. I believe they amended their collections management policy in anticipation of selling work to pay back a loan that they had taken out to, I believe, renovate their museum. I haven't read about the details of this in a while, which was a blatant disregard. I mean, it didn't fall into any permissible category of deaccessioning under anyone's point of view, but they decided, or the director and board decided to do that anyway. And I think we are seeing perhaps a desire or willingness by some museums to say, you know what, I'm not going to follow that rule right now. And if, the repercussion is that AAMD sanctions me, or I'm not an AAMD member for some period of time, then maybe that's okay. I'd love to hear Jill's thoughts on that. That hasn't fully come to bloom yet, but I think the last 2 years, we've seen a lot more willingness by museums to sort of go their own way and depart from the AAMD's rather strict view of how these proceeds can be used. I mean, the Berkshire Museum is a great example. I think even some of the creative stuff the Brooklyn Museum is doing around creating funds to fund direct care, meaning investment funds where the income from those investment funds will kick off for an indefinite period of time to pay for direct care, including salaries. We're just, it's changing, and I wonder if the influence of these ethical guidelines may become less, less strong.
Katie, a follow-up question to you. So when Baltimore Museum announced their plans to deaccession a few pieces, right, there was an intent voice that they would be buying other works of art. Theoretically, it's permissible use of funds, right? If you use proceeds from selling certain objects to buy other objects.
Yeah, but the problem, really, I love that question, and Jill's going to be way better at answering it. But my, 2 things on that. One is what you can't do under any of these guidelines or in New York is say, you know what, I want to buy this new work by this new portrait by this hot young artist, so I'm going to go find a work of art in the collection to sell. You have to already, for the reasons laid out in your collections management policy, which is informed by AAMD, and in New York, informed by Regents, you have to decide it already that this work, it's time to deaccession this work because of its own qualities. You know, in and of itself doesn't fit your collection anymore. And so you deaccession it regardless of whether you are going to use the proceeds or not use the proceeds. And then it just goes into a pot. And that pot sits there until you have some, you know, legitimate need to use it, which is usually buying a new piece of art. So I think that was a problem in the Baltimore example. And honestly, it's not unique to Baltimore. This idea that we want to diversify the collection. And so we're going to go find some works that we don't consider diverse, and we're going to sell them because we know the works we want to buy already. That was not permissible under the generally accepted scheme. The other thing Baltimore did was it also wanted to use funds from these works of art to pay for things like increasing salaries, staff raises, public programs, a host of things that are clearly not purchasing new art. Some of them might arguably be direct care of collections, which is permissible, as we've discussed, under AAM in New York and under really all the other guidelines except AAMD. But that is a question that people debate, whether a salary is direct care of collections. Ultimately, literally every expense any museum has is direct care of collections, right? Because the janitor, the electricity bill, the cafeteria, like everything eventually you could link to the collection, but we've line drawn before. And so now I think the question is, where is that line? And the thing that Baltimore did was also was controversial that Jill can really speak to, is that I think there was a suspicion that the works they selected were not actually works that should be deaccessioned, that these were high profile, rare, valuable, one of a kind objects by these artists, one of whom was living still. So it just was odd for those host of reasons.
Jill, do you want to address this? We want to deaccession that piece and accession another piece. What's the problem?
Actually, there's Baltimore 1 and Baltimore 2. So Baltimore 1, and forgive me, I forget the date, but it was not so long ago. They did just that. They deaccessioned a number of works and reinvested in the collection, focusing on BIPOC artists, women of color, and members of the LGBTQ+ community, as I recall. That is actually legitimate. I mean, you may question some of the works that they selected to sell, but I think that's in the gray zone. Baltimore 2, when Andy Warhol's Last Supper, a work by Bryce Martin, who's living, and Clifford Still, who gave very, very few of his works away ever, had given a piece directly to Baltimore. That was more problematic, not only, or not so much even because of the works that they had chosen, although that did raise a few eyebrows, but how they were proposing to use the funds, because the museum was quite clear that they were focusing on rebalancing, not just the collection, but the staff, the salaries, in the name of DEAI. And I think that there was this somewhat confusing conflation of equity and deaccessioning. I don't know a single museum director who is not working nonstop to advance equity, diversity, inclusion in their museum. But I think that's a separate subject from deaccessioning and use of proceeds. I really can't make the argument that that is direct care, with some very, very tenuous and very limited and perhaps very tenuous circumstances in terms of, say, a conservator that's on your team that is actually ensuring the physical longevity of that piece. So that's really, I think, where the problem was with Baltimore 2. And it loops back, Irina, to a point you made earlier about duties. One of the tensions that we haven't touched upon yet, Katie, you kind of glanced off of this, I think, is the opposing duties, the fiduciary duties of the board, right? So they are beholden to, if my law school days serve me well, to duties of care, obedience, and loyalty. Katie, is that right? The 3 duties. And sometimes that's going to come in direct conflict or create friction with these ethical guidelines, which I do feel still have a very strong bite Thank goodness, because we don't have a lot of legal guidelines or protections in the museum field. And I really see them as not only important, but still being very highly regarded and well respected by the vast majority of AAM and AAMD institutions.
What I found quite interesting with the Baltimore 2 story was the arguments made by the museum and the response of the public and the critics from the outside, because public doesn't really have a standing typically to challenge deaccessioning decisions. We can have opinions, but we don't have a legal position to defend. And as I recall, Baltimore reconsidered their plans. They did not proceed with deaccessioning, unlike other institutions. And ultimately, they were able to collect or receive gifts from other sources to be able to invest in the art they wanted to invest. So they were able to keep the pieces untouched, and they were able to raise funds necessary for future accessioning. It's not, what are your thoughts about this? Everybody played their role appropriately. Curators were arguing for new types of art in the collection. Public argued that these decisions were not necessarily sound decisions. And then donors stepped forward and assisted with the missing funds.
I think what Baltimore threw so many things into high relief. It not only really, not just catalyzed, but exploded the direct care debate. What is it? How do you define it? What's the litmus test? It also really elevated even further the tensions that have been latent for decades, if we're honest, in terms of pay inequities, the elite nature of our institutions to this day, which I personally trace back to how nonprofits and arts are funded in the United States. I think that that's something that merits real thought and attention. But one of my favorite concepts which has emerged from these debates, and I think again really was given center stage by Baltimore, was that budgeting is an ethical decision. If you think about that in the context of museums, how you budget, where you choose to spend your money has very significant ethical reverberations. And I think that that's given the field a lot of thought. So instead of needing to generate millions of dollars to rebalance salaries, to really advance equity, what if we just chose to do things differently? What if we, instead of investing in buying more art, and I say that understanding that in many cases we have restricted funds where we can only buy more art. So I know it's not this easy, but what if we took what we had and just brought an ethical dimension, a diversity dimension to budgeting? I think all of these things percolated up in the course of those conversations, and it was helpful in that regard. It was helpful for people to understand, because we were on a national stage, how challenging some of these issues are and how critical philanthropy is still for our institutions. Because to the outside world, we may look incredibly wealthy as institutions because we are the stewards of such valuable or invaluable work. And the collectors who support us, the donors who support us, oftentimes occupy a certain strata in our socioeconomic hierarchy. So again, I think to the outside world, it may seem that everything's fine and that we're just not prioritizing appropriately. But I think it was helpful in that regard for people to understand that there are a lot of financial pressures and that there is this tension between DEAI imperatives and some of our lived realities at museums. I'm not sure if that really answered your question, but
I think it gave a lot of food for thought. And we just shared with you the Smithsonian announcement that they are adopting a policy on ethical returns. So I think the question of ethics as well as law and soft law, because that's what I call AAMD guidelines. I don't think they're quote law. They're also quite painful if somebody, I presume, is sanctioned or listed. So this is a really interesting insight. Thank you. Katie, I have a question for you. When a museum decides to deaccession something, theoretically, do they have to notify donor or the source of that gift? And if they can't do that, what's the next thing or next step that you anticipate museum needs to take? There are a couple of questions we received about donor relations. So if we can look into that direction.
No, it's a great question. I'm going to let Jill answer it because she, probably sees this a lot directly. But from a legal perspective, you look at the gift instrument. In an ideal world, every gift is unrestricted. So it's a best practices. I believe it is the best practice for every museum to try to notify the donor when something happens to a work they gave, or the donor's family or heirs if the donor is deceased. That is not always possible. But I believe that there's a few steps you take to try to notify the donor or their next of kin when a deaccession or damage or anything happens to a work. But the real bind is looking at that gift instrument and seeing if there's any contractual obligations that get in the way of the museum's plan. Hopefully there aren't, but that is a really important first step, because none of these soft laws matter at all if you are legally prohibited from deaccessioning or doing something with the piece of art. You don't even get to that ethical consideration. Jill, I don't know, what have you seen done with respect to donor notification?
Katie, I think you answered that question really very well, that it is best practices. It would be unusual, for example, for there to be a clause in a deed of gift, an unrestricted gift, that the heirs or the donor would be notified. But I think that most, if not all, museums feel that it is ethically incumbent upon them, and also just wanting to be a good neighbor in the art world, and as the recipient of charitable largesse, to make sure that a good faith effort has been made to inform the donor or the heirs. And we haven't talked about 8283s, but there's also that little wrinkle in terms of tax write-offs, and if it's within unless the law has changed 3-year period,
yeah,
the donor is,
right.
the donor is going to have to go ahead and file an 8284 to amend their taxes and the write-off that they would have enjoyed for that charitable gift.
That's brilliant, because I was going to ask you a question we were posed earlier. If a work is deaccessioned, does it mean something to the donor who might have taken a tax deduction for that donation? So I'm not sure if we have tax experts in the room per se, but probably the time period between when the gift was made and when deaccessioning took place plays a role in that filing, right?
Yeah, you have three years. So this is, again, as Irina said, exactly, it's a tax issue. But why do people donate works to charities? Because they get, or money to charity, is because they get a tax deduction. And so you essentially lose that tax deduction retroactively, which is even more painful if the museum or whatever, the charity that's received your gift disposes of it within a 3-year period, or if the gift was deemed not to be within the charitable purpose of the institution. That's not really an issue when you're donating art to art museums. Clearly that's within the charitable purpose. So really looking at the 3-year period for keeping the tax deduction. I'd also add, because this has come up in a lot of other talks on deaccessioning the last couple of years, and I think it is important, this idea that it's not about just about your legal obligations to the donor, which are often none, but the purpose of the staff of the museum is in large part to court donors and to get substantial donations to keep operations going. And if donors feel like they can't trust an institution to do with their gift what they think is right, they may stop giving. And this is sort of a waterfall fear that came out that I've heard expressed out of the increased desire to deaccession and use funds for operations or things like operations, that it will drive donors away and in the end actually hurt budgets more than it helps them. And I don't know if that's true, but I do think considering how donors look at these policies is practical and is actually quite important, right? That keeping in mind how donors are going to view museum behavior is essential to keeping a museum
Thank you very much. We're getting very good questions, so I'm going to introduce them momentarily. Do you have questions for each other? Because I know that you have talked about deaccessioning previously, before the pandemic. Have you had any other interesting observations or changes that museums have adopted as a result of this exception from AAMD? Are museums changing their long-term strategy vis-a-vis deaccessioning? And any suggestions that you might have for our audience to think about when hearing or looking to deaccession?
I don't think that long-term change is here yet, only because that resolution, the AAMD resolution, has expired, and AAMD members, the ones that are truly vulnerable to AAMD sanction, which is actually a really big deal. It's not just reputational, it's about the ability to exchange works of art through loans for your temporary exhibitions and those sorts of things. So I don't think that big change is here yet. I also don't think there's an appetite for big change. There are the outlier institutions that are really kind of pioneers and more willing to operate on the fringes of these ethical considerations, but I feel that we're mostly clustered in the middle or right of center in terms of collections, because there is a very real nervousness, particularly amongst embedded institutions, so that those are college and university institutions, as well as municipal institutions. And Detroit is paradigmatic in this regard. If we think back to what happened at Detroit when the recession of '09 hit, there was a move afoot, as I'm sure you recall, to liquidate some of the more valuable works of art. That, to go back to your earlier question, Irene, is a kind of worst case approach to deaccessioning. So those institutions tend to be the most vulnerable because they are part of a larger entity. So I feel that most museum directors, at least in my orbit, acknowledge and accept the need for some fairly strong ethical guidelines to keep us all in a coherent and cohesive place in terms of shared values and standards.
Thank you. We have questions about, they're not necessarily legal questions per se, but, and I think many of them have been answered. For example, decisions on museums changing their mission, for example, right? And Jill, as you said, these big sways, let's start from scratch. Let's reconsider all the sources of donations, the philanthropy that came before today, remove all the names from all the buildings and start from scratch. These are very big decisions and probably not what the society ultimately needs. But because that makes me think of, the Soviet Revolution, when everything was nationalized, lots of objects were sold, many precious objects were melted down, and that was such a drastic attack on the previous way of preserving culture and looking at culture. It was very detrimental. So instead, maybe, is there room for opening museums for new names, new artists, emerging artists, voices that we haven't seen, heard? How would you suggest accessioning of new art be structured, and where would the money and funds for that come from?
Well, there are two main channels or mechanisms for new acquisitions or new gifts. Well, those are my channels: gifts and acquisitions. So either you're buying it or someone's giving it to you. Now, if you're making acquisitions, if you have a budget for buying art at your institution, it's easier. And I go back to this idea of budgeting, having an ethical overlay. You very simply focus on BIPOC artists, women, those underrepresented segments of the community in the decisions you're making. When you're really relying on gifts, or even if you're not relying exclusively on gifts, but you're accepting them, you obviously have a far less degree you have far less control. But that shouldn't stop the director or the curator from really focusing their energies, the time we spend cultivating donors, right? Gifts don't usually happen out of nowhere. It's because you've taken the time to make an overture, to build a relationship, to foster a sense of trust, to inspire that gift. So if you know or feel that you really want to focus on greater diversity, then you should probably be echoing that in terms of how you spend your time, focusing on collectors whose collecting interest mirror your own or your institution's priorities. So I do think that there are ways forward. And I do think that a tremendous number of museums are really doing that, leaning into that. And I did see a comment, really about museum practice and our need to look internally at how we do our work. And I do feel that that is happening in a very serious and profound way. But we didn't get here in 2 years, and we're not going to get to a place of greater parity in 2 years either. So there's a lot of work left to be done.
Katie, when you advise museums on changing their deaccessioning policy or adopting a new deaccessioning policy, or looking at what they accession in the first place, what do you want curators to keep in mind from the legal point of view?
Well, I wouldn't be dealing directly with curators, but I think, as we've said, these policies really come out of models that are promulgated by these ethical membership organizations like AAM and AAMD, and they're required. So a few things are required. You want to have a collections management policy that is approved by the board, that is reviewed and updated regularly. You want to publicly define what direct care of collections means if you're using that as a mechanism for funds from deaccessioning. You want to make that definition publicly available, which not all museums, even big museums, have done yet, but is required both by FASB and I believe by other guidelines as well. And so being thoughtful, public, and board involved about the deaccessioning process is really important. And it raises all these issues, right? Because boards are made up increasingly not just of the richest donors, although they are for sure there. Whether they want to stay there or not with all this, I don't know. But it's also, artists, and it's the boards of these major museums are a mix of people who have different views about a museum's role in social justice issues, in community outreach, in diversity, equity, and inclusion, and all these issues come up, at when these policies are being debated. So it's really important, actually, for the board to be reviewing them and talking about these issues on a regular basis to solidify what an institution's role, mission, and goals are with respect to deaccessioning and these broader issues we're talking about. And I know Ann Pasternak completely publicly, I don't know her personally, has at least at a couple of events I've seen, expressed some skepticism about the long-term viability of the AAMD guidelines. And Brooklyn Museum has done a very interesting thing where they have created, as I said, investment funds from the sale of some of their art to fund direct care of collections. Now, as Jill has told us, the moratorium from punishment by AAMD sort of indirectly permitting the use of deaccession funds for direct care of collections is elapsed. It's over. So what happens to these investment funds now? They continue. They kick off income. That income is still being used for direct care, perhaps in a very broad way. And so I think we are, maybe things aren't changing drastically, as Jill said, but I think things are changing. There are new ways that money is being raised. There are new uses to which this money is even indirectly being put. And I think there is some pressure and skepticism by some major stakeholders to think more loosely than perhaps AAMD has been.
Last question. Thank you. These responses are really thought-provoking, and I hope we'll have time to unpack them after the program. We'll have our reading lists. We'll have the recording shared with our attendees. Last question. I sent a call for last question, and we got a few repeated questions. if you remember, Metropolitan Museum of Art and others, I'm not picking on them, but they're big and they can take it. They were asked about restitution nicely and then more firmly. And some museums choose to fight the request for restitution using the subject of deaccessioning as impossibility, right? There's a gift that came with certain conditions. If we return it, the conditions are violated and triggers a lot of other legal problems. How deaccession guidelines restrict the process of restitution, and how can we think maybe creatively about dealing with this non-financial or economical problem in the first place? I have a thought, but I really want to hear from the two of you. The restitution, hurdles to restitution through the lack of deaccessioning policy.
I think it's really important to remind the group that Europe is actually very different. I don't know about the rest of the world, Europe versus the US, but in Europe, as I understand it and in my experience, deaccessioning is not allowed, full stop. So there is this real, not resistance, but this real, a true hurdle to restitution that I think is much more difficult in Europe than it is in the US. I don't see a deaccessioning policy as being a real hurdle for restitution and repatriation. I think that there are a whole bunch of other issues that may be getting kind of mixed up with the deaccessioning debates, and I'm not even aware of, and this is a reflection perhaps of my having missed some important headlines of a museum kind of waving that flag, saying, oh no, we'd love to restitute and do the right thing, but we can't, we're sorry. Because I think that the public and the field would see right through that. What gives me hope, and I have a lot of hope in all of these conversations and all of these debates, is to see what's happened at the Smithsonian, for example, and at other institutions. And you flagged this earlier, this real acknowledgement of doing what is not the legally correct thing, but the ethically correct thing. I think there is this very clear acknowledgement of owning our past that maybe does not have any mens rea attached to it necessarily, but is still deeply problematic and out of sync with our stated commitments to DEAI. So I think for me at least, deaccessioning is the least of the complicating factors in the realm of restitution and repatriation.
Yeah, I agree with that. I think that's a totally separate talk, really. And it's a whole different set of issues, usually does not come into play, except that restitution is one of the reasons you can acceptably deaccession, right? It's one on the long list of, work is fake, it's duplicative, it no longer serves the museum's purpose, it's stolen, doesn't belong to you, restitution's appropriate. Like, it's just one of the reasons, but it kind of takes on its own debate outside of the topics around deaccessioning. I think we've talked about today. And I think, but to be fair, museums do restitute works. So it does happen. I think we're going to see it increasingly happen.
Thank you. These are really good answers. And we have Giulietta to thank for sharing a link about deaccessioning in Europe. If you, just as a closing remark, and thank you all for staying with us a little bit over time, Met ultimately did return a lot of pieces to Greece and I think Italy. And in exchange of the thanks, they were using arguments that maybe their donors would be disappointed, they would be losing donations if they start returning pieces legally imported, etc. There are lots of arguments made. But ultimately, after objects were returned to their countries of origin, there were new loans created and new objects came for temporary or prolonged durations to the United States, to these institutions. So looking for creative, fair, ethical solutions is a great alternative to bad deaccessioning. But I think the takeaway should be deaccessioning is one of the tools that museums have to stay healthy and to stay relevant. And it's just one of the subjects, not the most important or the only one, but one of the elements. Thank you very, very much, Jill and Katie, for being with us today. This was a very interesting conversation, and we usually don't have this Q&A from start to finish, but I think it was great. Please come back whenever you want, in person and through webinars, and have a lovely day, everybody. We look forward to seeing you again before the end of May, and every time we have an event in person or in the digital space.
Thank you, Irina.
Thank you,
Thank you,
everybody.
Katie.
Yeah.
Bye.
Thank you.